call the case of Mill Pond Manor versus, is it Changning Pond?
Yes, Your Honor.
Good
Yes.
morning. Good morning, Your Honor. James Martone appearing on behalf of the plaintiff.
Good morning, Your Honor. Student Attorney Calvin O'Connell, joined by my partner Allison Futter and our supervisor Sarah Sallin from the University of Michigan Civil Criminal Law Clinic on behalf of our client, Mr.
Boy,
Fan.
that's a long intro. Go,
Apologies,
go,
but
go on.
there is more. We
There's
are,
more?
I
Okay,
know.
go for it. I got all morning.
We are requesting permission to practice in your court under Michigan Court Rule 8.120 with the supervision of Ms. Sallin.
Have you been before me?
I have not, Your Honor.
I didn't think so. Where are you from?
I'm from Seattle, Washington, Your Honor.
Oh, it's really damp there. It's like rain, just rain. It's just, I don't know. Anyway, so where'd you go to undergrad?
The University of Washington in Seattle, Your Honor.
Oh, is that different? That's different than UW.
No, that is UW, Your Honor.
Is it? They're in Seattle?
Yes, North Seattle.
You understand that they beat my Maryland Terrapins, so you're in trouble. You should have said that was not the school.
I mean, I don't know if you know this, Your Honor, but I did switch sides after we lost the national championship. So I'm here at Michigan now. That's where my allegiance.
You didn't belong in the game. Listen. Anyway, I don't even know why you were there, but that's okay. All right. So are you from Washington?
Yes, Your Honor.
All right. So you went to UW and now you're at Michigan.
Yes, Your Honor.
Okay, I'll let it pass. Permission to practice is granted. Go ahead. Good morning, Miss Sullivan. Yeah.
Good morning, Judge.
All right. What are we doing on this case?
Hi, good morning, Your Honor. This is a case for a termination of tenancy stemming from multiple breaches of a residential lease agreement. We're basically going to be asking the court for a trial date for us to seek a judgment of possession. I will note, Judge, that I did receive, it looks like, an answer in affirmative defenses from defendants, as well as a demand for jury, as well as a motion for summary disposition. And so I think just looking for a scheduling order, Your Honor, to address all those issues.
Well, that's not entirely how we would do it. I guess the summary, since this is a summary proceeding, there's a question of whether or not rental payments were accepted.
Yes, Your Honor, that is correct. We did move for summary disposition in this case on the basis of what we believe are multiple park forest violations. Attached to our motion are exhibits, the first of which being bank statements showing about 3 months worth of rent acceptance after the August 22nd move-out date specified on the notice to quit. The second exhibit we have is a signed HUD recertification signed by Mr. Fan and the building manager, Mr. Christopher Writings, if I'm pronouncing that correctly. That's from September 30th. And lastly, we have a notice of processing of that HUD recertification and a subsequent rent increase that was sent to Mr. Fan. That rent increase was actually set to take place tomorrow. All of which occurred, several months after the expiration of the notice to quit, and aligned pretty neatly with the dictates of Park Forest there. And I will note, just briefly for the court, that Mr. Fan is with us here on Zoom. However, he has recently suffered a stroke, as a result of which his blood pressure consistently sort of reaches dangerous highs in stressful situations. So I just wanted to flag that for the court in case he does become unavailable momentarily. But in any event, for the sake of his health and on the basis of those pretty straightforward notice violations, yes, we are asking that you grant our motion to dismiss today.
Your Honor,
Yes, go ahead.
If I may address that, the Park Forest case doesn't apply here. This is not a non-payment of rent termination of tenancy. This is a termination of tenancy as it relates to multiple violations of, unauthorized destruction of process or unauthorized modifications of premises, destruction of property, aggressive behavior, all other types of.
Yeah, but that's fine, except that the basic premise behind Park Forest isn't necessarily that it's a non-payment of rent case. The basic premise is that the landlord has done things that have led the tenant to believe that the tenancy continues, despite what their complaints may be, whether it be non-payment or whether it be termination.
Understood, Your Honor. Understood, Your Honor.
So,
If I may, Judge.
yeah, go ahead.
We have been engaged with Mr. Fan's prior counsel in negotiations of a settlement with respect to this issue. They have been on notice that we've been postponing filing the lawsuit as we engaged in those discussions. It wasn't a situation in the Park Forest where the tenant was led to believe that the notice to quit was waived. Here, at all times, prior counsel and Mr. Fan was aware that we were continuing to enforce the notice to quit, and we were engaged in settlement discussions as a result, as it relates to that. As recent as end of September, Mr. Fan's prior counsel did identify that they could not reach an amicable resolution and suggested that we go ahead and file the complaint at that time. So this isn't a situation where Mr. Fan was led to believe that acceptance of rent or other actions waive that termination of tenancy notice. In fact, at all
I think that's going to be a factual determination. I don't know that one that I can make just on the thing. I understand what you may be saying, and I'm not sure. Well, I won't go into that. All right. So first thing is I'll need an answer to the motion for summary disposition. How much time do you need to do that, counsel?
Let me look. Sorry, Judge, just looking at my schedule. I'm out of town next week. Is it possible?
Then we'll do it then. No, go ahead.
Yeah, no. Is it possible to? Do you need an answer date or a hearing date?
Yeah. Well, I just need. How much time are you going to need to file an answer, and then I can give you a hearing date.
If I could file an answer by the 14th, that would be sufficient time for me, Your Honor.
All right. So I'll indicate answer to motion by November 14th. I'm not going to need much time to necessarily look at that and grasp the issues. So when's my next Tuesday? 3? No.
Oh, Tuesday. December 2nd.
That's my next day.
I'm sorry, November 18th.
November 18th. I can, if that gets in by Friday, then I can look at it and be able to deal with it over the weekend. All right. So what I will do is to move this along, I'll need the answer to the motion by the 14th, and then I will set it for a hearing on the motion and a pretrial for November 18th. That's an in-person hearing. That's a Tuesday, and that will be at 9 a.m. And then I'll hear argument on it and then we'll see whether we go forward.
Thank you, Your Honor. Judge, I'm sorry, Your Honor.
Yeah.
One housekeeping matter. I will note that Mr. Fan filed a complaint against Mr. Ridings in a separate matter. Is that it's case number 254C1603. It looks like it was a pro se filing. Is the court going to address that in due course, or is that something that we would consolidate?
My short answer would be no, but you have it.
I do. That was filed as a general civil matter.
So it's before Judge Barr.
Correct.
Okay. When was that? When was it filed?
It was filed on September 29th, and I'm not seeing any activity past that.
So nothing has gone forward on it. All right. What I will do, I don't know that I can give you a straightforward answer. It's likely that what we'll do is we'll contact Judge Barr and probably bring it over because it doesn't make sense to, I don't know what the issues are in that filing. But it would seem to me that if they relate to the tenancy, it would be best that it be handled in one place, so.
And it looks like
I will talk to Judge Barr about that and then we'll deal with it on the 18th.
Thank you, Your Honor. I appreciate it.
All right. Okay, thank you, folks.
Thank you so much.
Thank you, Your Honor.
Take care. Seattle, have a good weekend.
We'll try. Thank you, Your Honor.
Yeah, all right. Take care, guys. Court does call the case of Cross Street Apartments versus Hannah Schumacher.
Good afternoon, Your Honor. Norman Whitty, appearing on behalf of the plaintiff, Cross Street Apartments.
Your name? All right. And folks, where are we on this case?
Your Honor, if the court recalls, we had a first hearing on this over Zoom, and Ms. Schumacher raised an issue with trash collection at her apartment. And I've had a chance to talk to her and talk to my client, so I thought I'd give the court a brief update as to what the issue is.
All right.
And how we're hoping to proceed. The problem is that these are second floor apartments in a two-story building, and the building's lot line is the building's perimeter. So there's no place to put external trash cans. Historically, there have been trash cans on the sidewalk. That's been the way it has been for years and years and years. Recently, the city of Ypsilanti's code compliance people have been ticketing and refusing to allow the trash cans there. There's no place else to put them.
So the city of Ipsy's been ticketing.
The owner and
Okay.
tenants for having trash cans on the sidewalk. The problem is we can't put it inside the building. This is one of those buildings where you open up the door, there's a vestibule big enough for the door swing, and then there's a staircase going up to the apartments. So we can't put it inside. There's no place off street to put it because my client doesn't own any place off street. So I think Ms. Schumacher is very reasonably saying, I don't want to drive 45 minutes to my parents' house to get rid of my trash. And I don't have a problem with her escrowing the rent. I'm getting up to speed on this now. What I want to do now is go back, read the city's ordinance and talk to them about this problem and try to find a resolution. So I think the best thing to do would be to kick this back a couple weeks to give me an opportunity to sit and talk to the city and see if we can't find a solution that works for the city, for my client, and for Ms. Schumacher, who absolutely should have a way to get rid of her trash on site.
What do you want to tell me? Thank you, counsel, for that.
I mean, I agree with pushing it back until the issue gets.
So that is very strange to me because I don't think in all the years I've been doing this that not having a place to put your trash has ever been an issue.
New one for me too.
I just have not heard of that. And when you were telling me at the first hearing, I'm thinking to myself, okay, what's this lady talking about? Thank you for getting that clarified because I wasn't sure when you were saying about the trash issue, and then we got the documents, and I'm still trying to. I don't understand. Like you just have no other place to put it.
Right.
So what have you been doing?
I've been driving it 45 miles one way to my parents' house to dispose of it properly.
That's not acceptable.
Bless your heart. Okay. Yeah, that's not. What other, are there other buildings around that?
And that's actually another part of the problem is that there's another apartment building that my client doesn't own next door, and their tenants also tend to be putting things into any receptacles we have on the sidewalk. And so, you know,
Do they have the same issue, you think, or?
I'm not sure about that. It's too early for me to know that.
Know that. Gotcha.
But, you know, from my standpoint, Your Honor, I totally understand where Ms. Schumacher's coming from. My client has been diligently trying to resolve the problem, but they haven't involved me. And as you know, attorneys have some other tools that maybe
Right.
the manager doesn't have. So I'm hoping to sit down and see if I can't work a resolution of this.
And just one other question. So they've been ticketing the owner for the trash that's outside.
So for example, Jimmy John's is a tenant downstairs in the building, and they've historically had their trash cans outside for years and years. And now code compliance is saying you can't. So my client got a $200 ticket for Jimmy John's trash cans sitting outside.
Because Jimmy John's is a tenant of your client.
Correct.
Right.
My client represents the owner.
So, okay. I'm just going to ask this question out loud. I don't expect an answer because you probably, neither one of you probably know. How do you allow a restaurant to open without having looked at whether or not they have the ability to dispose of things? But you would have done that because that's the way they were doing it.
Well, so there's two answers. First of all, what Jimmy John's is doing now is they're keeping the trash cans inside and then putting it out around the collection times. But again, I mean, this building is an older building.
Yeah.
It probably predates the code. My position is these are grandfathered uses because it's been done like this since the beginning of time. But saying that and having code compliance agree with me, there's a long path to walk between here and there.
Oh, have you dealt with the city?
No, I'm sure this is
That's a
going to
much
be
longer
fun.
walk than you probably are in.
We're going to find out.
Just gonna say that. How much time do you think would be?
I'd like to kick it a couple weeks and then come back by Zoom. I don't want Ms. Schumacher to have to come
Okay.
forward on these
All right.
things because I don't think we have any factual disagreement between us. We're not going to need a trial. We're just going to need to find a solution.
Okay. And I'm just saying, if for whatever reason you don't get to where you need to be, if somehow or another you interplead the city, then I could foresee a settlement conference with you representing your client, Ms. Schumacher, in the city. Because
Your Honor, that's
you're right, she should not have to be doing that.
No, not at all.
All right. So I have 7th, 14th, 21st. Well,
Let's,
be right before Thanksgiving. So which would be better for you, man? Why don't we?
I'm sorry, what's the date
The 7th, the 14th, and the 21st.
of November?
If you watch more football, you'd be able to follow right along. But anyway, go ahead.
The 14th.
14th would be.
Or is there a later date?
I have the 21st.
that's
You want
fine,
to do
Your
that?
Honor. I don't
Okay.
expect the city to be moving at the speed of lightning either. So
Your expectations will probably be well, never mind. We'll adjourn this to November 21st, 2025 at 3 p.m. That's an in-person hearing. However, what I will do is I will allow the parties to appear via Zoom given the circumstances.
appreciate it very much, Your Honor.
All right. Anything else, Ms. Schumacher?
There will be no judgment.
There's
Ms. Schumacher? I do a lot of these hearings. Okay. Right now, don't you even worry about that. I think the ultimate issue is to try to figure out how to solve this problem for you. All right. I mean, certainly for the landlord, but really solve the problem for you. You shouldn't have to be doing what you're doing.
just to give Ms. Schumacher a little bit of comfort on that issue. She's been very reasonable to work with. She's putting her money in escrow. I don't need an order for escrow. She's going to give me the information on that. And just so you understand, the most likely outcome, if we work this out, would be something called a conditional dismissal. And that would provide that you would then pay the rent because you're satisfied with the situation and the case is dismissed. So I don't see, based on what I know now, any point at which I'm going to ask the judge to enter a judgment against you. I mean, things could change, but I don't see.
And now knowing what I know, even if he asked.
Get it.
All right. Okay. Ms. Schumacher, thank you. You have a great weekend.
Thank you.
David Sawolski versus Lisa Lauro. Lisa Lauro. And what about Maria? Okay. Your name, sir?
David Allen Sawolski, sir.
Okay. And there was supposed to be a written answer filed. How much is a non-payment of rent case? How much is You did follow.
I wanted, I wanted a 1.5 month, $2,400 security deposit. And, now she owes 3,200 in, back rent because, she can't, I
Hold
took
on a
over.
second.
What happened, sir, was I took over the property on September 26th. I bought it.
Okay, yes, I recall.
And so, for her to stay there, I would want 1,600 per month, but that started on September 26th.
What was it before?
That was between her and the previous landlord.
So at what point did you give her notice that that was now her monthly rent?
Same date.
In writing?
No, sir. I knocked on the door and she answered it and I told her that I want rent if she was willing to
On
pay.
what date did you do that?
September 26th.
And so then you were gonna charge 1,600 for October?
Yes, sir. If she
Why-
paid
Then
it,
let me just ask you this. Why do you think you would not have to give her 30 days notice at minimum before you change any condition of her rental circumstance?
I'm not sure about that, sir.
Yeah, I can tell.
Yeah.
So
We had no agreement.
He came to my door and my daughter was there. Both of my daughters were there when he offered me the agreement and said he liked my dog. He said that he did not want to bother me for a down payment and that he would honor the $1,200 a month.
did you
I
tell
asked
her
him
that?
24
No,
hours
sir.
to think about it and I called him back and said, I agree.
Hold on a minute. Okay, but
No, sir.
so what are you claiming she owes?
Well, for her to stay there, I wanted,
No, 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 no.
okay,
You filed this as a non-payment of rent case, saying
Yes.
that she hasn't paid rent.
yes, sir.
And in that complaint,
Yep.
you basically indicated that, first of all, your complaint doesn't say anything about how much she owes at all. That's blank. Then you're saying that the rental rate is $1,600 per month. What I'm hearing is that is not true. And I don't,
I originally offered her, sir, 1,200 if she paid me that same day.
your complaint indicates there's nothing about a $1,200 offer. I don't know what this whole offer thing was, and I'm not necessarily, at least at this point, going to get into it. But there was no agreement between the parties. And assuming she's, say, a tenant at will, or that you would change a condition of her tenancy, that you gave her properly 30 days notice to up her rent. Yet you filed a complaint that says that the rental rate is 1,600. Frankly, sir, that's false.
Okay.
Then you don't say, you say no rent is due, right?
Which item is that, sir?
Pardon?
Which item would that be on the complaint?
Look on your complaint, paragraph 5, C and D.
Yeah,
There's nothing.
yes, sir, I overlooked that. I'm sorry.
Then, so if, as you're indicating, you purchased the premises, if she were a tenant there, what happened to her previous security deposit?
I don't know that I have no idea. I have no idea if she paid one.
I did pay one, that's why I feel.
Well, hold on, hold on, ma'am, just
What
take a
I,
breath, please. All right. How much did you pay as a security deposit?
Was 2,400.
Thank you. So if you purchased the premises, you would have had, she was still in the unit. That means you purchased it subject to, put it in legal terms, her leasehold estate. You then become her landlord, which means that then you are the one that is responsible for the holding of her security deposit. So where's her security deposit?
I have no idea. The previous landlord told me she hadn't paid for 13 months.
That was
And-
I don't,
And he told me he had no
I don't,
security deposit.
I don't care what the previous landlord said.
Yeah.
But if you took subject to a leasehold estate, you would be required to figure out, I've got a tenant in there, have they paid a security deposit? Because then you're the one that would retain it, or he's got to return it to her. But I don't know how you ask her for another security deposit, because here's what would end up happening. Presumably, you've taken that $2,400 security deposit. That security deposit that is she previously paid, and any security deposit tenant paid, is never the landlord's money. It belongs to the tenant. Which means that if, as you want in this complaint, for her to pay another $2,400, that means she would have theoretically a $4,800 security deposit. Even if I were to permit you to have the $1,600 rental rate, which I don't think can be imposed, you would only be able, 16 plus 8 is what, 24? The maximum amount of her security deposit could be 24, which means that you would be charging her twice the amount of a security deposit that legally you could require that she pay, which is going to subject you to damages.
Okay.
So that's where we are. Be honest with you, I think you bought this property without fully thinking through what you needed to do. You can't force this woman to do certain things and just automatically like appear at her door and claim that your rent has gone up by a third
Yes, sir.
on my say so.
Yes, sir.
Where in the heck does the $4,000 come from that you're saying that she owed? Oh, that's the 1,600 that you're claiming, which is the improper rent plus the improper security deposit.
Yes, sir.
That's where they comes up in the notice to quit.
Yes, sir. I wanted the 1.5 months security deposit plus the
You
$1,600 a
need to
month.
go to the previous owner and find out where her money is. Because you're supposed to be the one now that's taking over a leasehold estate. You're the one that's supposed to retain it. And you're supposed to give her notice of where you're retaining it.
Is she required, sir, to provide proof that she gave a security deposit to the previous landlord?
Yeah, I have my. previous-
Hold on. You are requiring her to do some things and shifting the burden to her. I will call upon her to provide proof when it's necessary to provide proof. But I don't see anything in the beginning of this that you did that's right. At all. Have you asked the previous landlord if he has a security deposit?
I did not, sir.
See? And so now what you want me to do is ask her whether or not she paid it. Quite frankly, I'm going to say this to you. Not sure what she wants to do. But what's going to end up happening is both you and the previous landlord are in up getting sued. So my question becomes, what do you want to do with this case?
Well, indeed, if she paid a security deposit to the previous landlord, and it looks like the security deposit I asked for is no good.
Well, but where is her money? The security deposit, did you hear what I said?
Yes, sir.
The security deposit belongs to the tenant and is to be held by the landlord, but it's her money.
Yep.
So somebody needs to find it.
So I would need to contact the previous owner and see what.
I don't know what you would need to do. All I'm telling you is somebody needs to find out where her money is.
Okay. I'll contact.
Moreover, the complaint, while you certainly could amend the complaint, the one thing you cannot amend is the notice that you sent to her. That notice has numbers in it that make no sense based upon what I've just told you. However, you did file a notice that on its face looks valid, so I can't necessarily dismiss this case on subject matter jurisdiction. However, if you wish to proceed with this, you need to understand that at the very end of the complaint, and pursuant to the court rules, that you're signing that complaint under penalty of perjury. That information has to be true. I don't think that any of this is true.
Okay.
So you can make your decision as to whether or not you want to proceed with this case or not.
Well, I think it might be better to dismiss it and pursue possession.
Well, because she asserted her rights.
Well, because if she
I
put
mean,
it,
sir, get what you did.
Yeah.
You went to this woman, told her, based upon some representation that somebody else made about whether she's paid rent, not knowing the circumstances. Not sure that was any of your business, but that okay. You took the place, didn't get her security deposit, asked her for another security deposit, and then try to increase her rent by a third. So here's what I'm going to do. Okay. I'm going to adjourn this out 1 week. You think about it. You try to figure out. I'd suggest you go get an attorney. Because if she turns around and files a claim, you're going to have a heck of a time. I'm just going to be honest with you. But that's going to be your call. I am not, because it's not in her interest. She's unrepresented by counsel. I'm not going to, and she's appeared. While you're moving to dismiss, I'm not granting your motion to dismiss at this time so that she can also pursue whatever remedies she may have if she chooses to do so. So I'm going to adjourn this out to November 7th, 2025 at 1 p.m. That will also be an in-person hearing. And I am not precluding the two of you having a conversation, provided you want to approach her as your equal. Thank you.
thank you, sir.
Have a good day, ma'am.
1 p.m., November 7th.
1 p.m., November 7th.
Thank you.
Pleasant Lake Park versus Christopher Dennery.
Good afternoon, Judge David Morris on behalf of Plaintiff Pleasant Lake Park LLC.
Your name, sir?
Christopher Genoviak.
Okay.
Sorry about that. I'm a little hurt today. I had to step out of the home. I'm a recipient of SSDI at 100% since March of 2020. I just got some things I want to read. I don't know how protocol is around here, but I'm sure you'll tell me.
Well, it doesn't start with that.
Just start with this.
No, it doesn't.
I didn't hear you. I'm sorry.
It does not start that way.
Okay. All right. Cool. Thanks for your time.
Judge, this is our second hearing on a non-payment of rent matter. Current rent to retain possession is $495 with fees of $75, costs of $110 for a total amount of $680. We have had some discussions, but no payments have been made, and parties were unsuccessful in finding settlement. I should note, Your Honor, that it appears an answer was filed with the court, but I did not receive a copy.
We'll get your copy.
Thank you.
All right, sir, what did you want to tell me?
Okay. So they're not doing maintenance to force the default. I've spoken with attorney, like one of those free attorneys that you call on the number they give you on the form. I called one of them. They're like, yeah, you have like a brilliant retaliatory defense. I guess he's trying to do default and to quit. I guess I got the notice.
Do what?
I guess I'll just read what I have. I'll read what I have.
Well, let's not.
I don't want to jump the gun here, but I did. This kind of makes more sense. So they're not doing maintenance to force the default. They did not board up holes, but they set traps and they put poison outside the unit. Like when they should have just boarded up the holes. This creature, it's like a rodent. It's like nesting underneath my bedroom, like my bedroom floor. The skirting was never fully pulled back when he promised me that. We both saw this creature and he set traps that were too small. And then he put poison outside the unit. He never pulled the skirting back to put poison on its nest. There are multiple entries around this unit. Please, let me continue. I'm really sorry for wasting your time. We really shouldn't be here.
Ma'am,
So the skirting.
sir, you're not wasting my time. I'm getting paid.
Yes,
Go
sir.
ahead.
Yes, sir. Well, I'm unemployed. I lost my job like a few weeks
Okay,
ago.
go
Because-
ahead
because
with
of
your,
pain
go
and stuff.
ahead.
I know, I'm
Go
sorry.
ahead with your reading, please.
So the traps are too small. And Mr. Weasel, that's the name. That's the person trying to evict me right now. It's Mr. Weasel. Mr. Weasel and I both saw this rodent or creature, not at the same time, but it entered out of the lake. My rental unit is up against a small wooden line about 15 to 20 yards, and then there's a massive lake. So we both seen this creature. It is fat. It is large. It's like a gopher. It's like a beaver-rodent creature. So there's 10 points. There's 10 points. Almost done. So the traps were too small. He put, and we both saw it. We both know it's big. So I was trying to do walkarounds, and Mr. Weasel usually just sends his maintenance dude just to do the maintenance. And this maintenance gentleman is a kind man. He also lives in the park. And this gentleman also works for Mr. Weasel at the landscaping company. And let me point, for Mr. Weasel to send out this maintenance dude, he has to pay him double time. So he's a maintenance, maintenance man is an employee twice for Mr. Weasel. So we did schedule one walk around, but I was late returning from cleaning up a church festival. I spent 9 hours at a church festival on Monday morning. I was cleaning. We had.
So if they get rid of this
and I wanted to
animal, then
Yes, sir.
we're
Yes, Judge. Yes,
we're
sir.
all good.
We're all good. And let me just I have a couple more points. I know this is really going into banana
Do you
town.
know anything about the animal?
I did set up a trail cam.
Okay,
Okay.
sir.
But I don't want to use that. I need to finish my points. So he never contacted me. He was on the property twice doing maintenance that wasn't completed, and he never contacted me when I was in the house.
Sir, I'm going to stop you.
I know. I'm sorry. This is
No, I'm going
I'm
to
just being-
stop you. That means stop talking.
Yes, Judge. Sorry.
Counsel, do you know anything about this animal?
We know of the idea of the animal.
Okay, I have no idea what that means.
We've heard of the issue, but my client has not set eyes on any animal. The animal at one time maybe was a mouse, and then a rat, and a cat, and then a beaver, and a badger. And so my client knows nothing about any real animal. Traps were set, the skirt was tightened on the manufactured home, he has been out, or his management has been out on multiple occasions and has responded to all legitimate requests. The defendant
Sir,
had,
you need to turn around and face the front and not wander.
I understand the defendant set up trail cams. We've received no footage. We've received no recording. We've received no audio file, no video. The defendant claimed over the phone that there's hours of critter noise every night. There are neighbors to the defendant.
Let me just stop you for a moment. Might it behoove your client to just,
Board up the holes that are super obvious. I'm sorry.
I don't know
this is
at
3.5
what
months.
point I said I needed help with my sentence.
I know, I'm sorry. It's just,
Then you need to sit down and be quiet. Be quiet then if you can't sit.
we're cool. We're cool. We're cool. Yeah, stand still. Stand still. I know. I just gotta keep moving. I gotta keep moving sometimes. Sorry. I know. I'm sorry. Sorry. I'm really sorry. I'm sorry.
Might it behoove your client to just hire a company to come out and look and make a determination based upon evidence that they see as to whether or not this creature exists or not? Because quite frankly, if there's a company that goes out and they tell me, yes, there's an animal, then they can tell you how to eradicate it. If they say there's not an animal, we're going to be at a point that there's not an animal. And apparently not one that grows from a mouse to a beaver in no time at all. I've never heard of one in Michigan, but we'll see. All right. So how long, do you think your client would be interested in doing that, counsel?
Yes, Judge, I think my client would be happy to get an extermination company to come and write a report.
Yes. How long do you think it would take him to do that? Because I can put this over to the 7th or 14th. What would you? And I'm going to order escrow. So
Thank you, Judge. I think the 14th would be
a better thing.
better.
What does that mean? What does order ask for?
So I'll explain that in a moment.
Sorry.
I'm going to adjourn this to November 14th, 2025 at
2 p.m.
at 2 p.m. That will be an in-person hearing. How much is monthly rent? This
Monthly rent.
portion,
Monthly rent is $1,250, Your Honor.
but portion of it is paid.
Correct. There was.
What's his portion? Do you have Section 8 or something like that, sir?
Just SSDI.
So you pay your full rent?
Yeah, I've got, I'm not employed now because of the noises underneath my bed. Every night for 3.5 months. Like I can't sleep. I can't sleep at
Okay,
all.
your monthly rent is how much?
$1,250, Judge.
$1,250. All right, I'm going to order escrow in the amount of $1,250. That is to be paid within 7 days of the date that it's ordinarily due.
I have.
You have to, and what I mean by escrow, sir, is you need to bring escrow to the court as funds, pay them to the court until this is resolved. When you bring it to the court to pay, the $1,200 must be in cash. We do not take checks or other forms of money. Understood?
Not understood. I have additional comments that I'm not sure if he just wants to like evict me in the future again. But the bathroom floor is sinking by like 1.5 inches. Like there's like a hole in the bathroom floor sinking. There's like a hole. I've already made this maintenance request. And actually, so there's an animal. I found this out about 2 nights ago because I had missing food. There's an animal entering my living room through the vent. This is a trailer from the 80s. So like this past week, I've had like, and I know exactly which vent it is. I've complained about that. So like there's now an animal entering my vent that I found out 2 days ago, and it's been eating my leftover food. It's going into my living room. This is a super old trailer, like massive. There's holes all around. He's already boarded up 10 feet on the main stairs. He's boarded up 20 feet on the south side, and I'm asking for like 8 to more 10 feet.
What is your next point?
So my next point is this trailer. I want to. So here's my official request, Judge. I want a state inspector. I want something from the state
Then if you want
Because I
a
think-
state inspector, you can call them and have it
Okay.
inspected.
Yeah, okay, super. And then I'll find out about this private inspector in the future. Is that what I should be expecting? Because I want a state inspector.
I'm not gonna tell you to expect anything. You
Okay,
say
right.
you want it inspected,
I
you
want an
call and
inspector. I
find
want a
out
state
whether or
inspector.
not somebody's going to inspect it.
The
What's your
bath-
next point?
My next point is the bathroom floor sinking. I think this unit should be condemned.
Okay.
It should be pulled off the
We
property.
all have our thoughts and our process. I
Right.
don't know.
I'm going through that process right now. I'm just
Okay,
with green
wonderful.
thumb. So, but this unit needs.
Is there
needs
another,
barely.
is there another point?
That was Judge. I appreciate your
Is
time.
that it?
Yes, Judge.
Thank you.
Thank you,
Have,
Judge.
check the bathroom floor, please, counsel.
Yes, sir.
Judge. Thank you, Judge. Thank you, Judge.
Chris,
Thank you for your service.
Chris, we'll be in touch about, we'll give you some notice before we come.
Yo, hey, come here. You walk out of here with respect. Whether you like me or not, I don't care. You will not treat this courtroom that way. Am I understood?
Yes,
Now you may leave and you will leave in an orderly fashion. Go.
yes, Judge. I'm
Was that the end of that block? Thank God. All right, court can stand in recess. We'll be back unless somebody wants to go right now. Yep, didn't have any volunteers. All right, thank you.
May be seated.
Arbor Woods versus Ellen Patterson.
Casey Matson for the plaintiff.
Hello.
Hi.
What's your name?
Marty.
Pardon?
Marty, Marti, Cole. I'm the daughter.
You're the daughter. Okay. And you reside at the premises?
Yes.
This is Miss Patterson?
Yes, I do.
Okay.
My mom passed away in August.
Miss Patterson did. That's right. I now recall where we were. All right, where are we on this case then?
Your Honor, there is still a balance due and owing. We are requesting entry of a judgment today. But Miss Mari has failed to fill out a tenancy application and be approved for such. I do believe an occupancy application was filled out. However, in order to, continue the tenancy, she would need to fill out an application for tenancy within the community, which has not been done at this point.
So when was I supposed to fill that out? Because I thought that they were giving me till the end of November to vacate the premises. Nobody contacted me.
You're gonna vacate.
Yeah, I didn't want to stay past the end of November. I just wanted to the end of November to vacate the premises. That's all.
Your Honor, she did request until the end of November. However, my client was not agreeable to give until the end of November, so we would ask for a judgment at this point with 10 days.
When did your mom pass away?
August 14th.
Of this year.
She did.
So you just been scrambling since.
Yeah, I don't know what's going on with her beneficiary not paying her rent for the time of me being there, but
Right, that's what you said the last time, that there was supposed to. They haven't paid it and you haven't been able, this person that's receiving the funds hasn't
not done anything. So, and I'm not in contact with her, my brother, my sister. So, yeah. So, I mean, I don't know. In 10 days, that's not enough time.
You just don't.
Let
me ask you this.
Mhm.
Okay. I'm going to grant them a judgment because I think it's appropriate in the case for possession. How much time are you really looking at that? If I said you got to get out, what's the soonest you could do it?
November 30th. Maybe a few days before, but I mean, I need that much time because I just started back working. So I do have a security deposit I got to pay when I move. So I have to say.
I got you. I hear you.
I mean, we would object to that. This case was filed in September, so she's had at least 30 days already to.
Yeah, and I just started working this month
It's her brother.
in October.
Okay, hold on a second. Ms. Matson, what's your name?
Yeah, we haven't spoken,
Who is he?
my brother.
Yeah, you can come on up, as long as y'all ain't gonna fight.
I don't even know what he's doing here, but yeah, whatever.
All right, so what's your name?
My name is John Covington Jr.
All right, so what?
So I'm Ellen's son. I'm here to kind of give a basic background to this situation. She has been at my mother's house for over a year now. With
Who has?
Me.
Okay,
not being able to keep employment. It also already has had 2 evictions by my mother as far as paperwork when she's been at the home. I have talked to her.
so why does this matter to me?
So I've
Please.
talked to Arbor Woods of the situation of getting my mother's things out to put in my auntie's.
Oh no, that's what this is about. See, him and my sister have came over with a big U-Haul trying to put me and my kids out so they could remove all the furniture and take it. Those are my mom's possessions, and she did not leave them to him or to one person. And since I'm there, they gonna come and take everything so me and my kids can sit on the floor. Like, that's not right. And I would never do that to them either. When I leave, I'm taking everything with me.
Your Honor,
Period. And I'm moving. So why would he think that everything would be outside or that he could take it to my aunt's house? Me and my kids are using it as of now because we are staying there. And as like he said, we've been there for a year. We have.
Upon that situation, sir, it was to the point that the eviction had came out. That was the only reason we were over there to try to move the things. Upon that point, as you can, and their lawyer is right there, I'm pretty sure she can talk to who she's representing. She has changed the lock. Only reason I was at the house is I have a key to the house.
And I changed the lock because him, my sister, and my aunt tried to come over and put me out, and they tried to remove everything out of the house so we can have to sit on the floor.
I don't need to put any.
How are you removing the furniture, John, when me and my kids are sitting on it? How are you removing everything out the house and taking it to Pam's house when me and my kids are there using it? I would never do that to you. Shut up.
Things upon you guys.
What things? You don't have no thing. Listen, 2 officers came over. There was officers.
Be right with you in a moment.
I had to call the police on them because they came over trying to put me and my kids out and remove everything. So the officers told him, my aunt and my sister, that they cannot come over there and remove nothing.
Okay, but hold on a minute.
All I wanted was my stuff, which is.
You don't have nothing. Your clothes, I gave them to you when the officer was there, and he said that's it, and he told you not to come back.
Hold on. So when you guys pulled up to the building.
No, I was here. I didn't.
Just stop.
Okay.
Don't interrupt me. You can interrupt him all you want.
I'm sorry.
When you pulled up to the building, it said 14A District Court. Walked in here to District Court. I am not a probate court. I am not a family court. So all of this stuff that you guys are talking about, fine and dandy. I can't do anything about that.
I'm here to take her up the day as far as she has to be out, so we can.
Well, frankly, sir, you don't have any interest in this and haven't appeared until today. So I don't.
I've been at work.
Well, I don't care where you were. I'm just saying I'm on my 3rd hearing, and she's appeared at every hearing, and you haven't been here. And now you come in here and talking about you want to know what date. I'll give the date because publicly I will that everything's going to happen, but everything else is up to you guys.
No, I understand.
Counsel, how much is owing?
Your Honor, rent to retain is $3,140.96. cost of $186.00 for a total of $3,326.96. We would ask for that writ to issue after 10 days. This is a rented home. They don't have any interest in the home itself.
Got it. What I'm gonna do is I'm gonna find after finding no tribal issue as to the amount of rent that's due. I'm gonna judgment for possession to the landlord. The normal rent date would be the 10th. I am going to extend it a bit, ma'am. I'm not going to give you the 30 days to do it. I'm going to extend it to the 14th. And at that point, the landlord can take it. So writ to issue November 14th or thereafter, 2025. Right? Thank you. I might want to check that hallway, Alan. I'm walking along and having a great day. And then all of a sudden, not. Let's try this case. Northville Crossing versus Barbara Bargo.
Casey Matson on behalf of plaintiff.
State your name.
Barbara Vargo.
I'm her husband, Michael Bargo. See, when he says I'm her husband, he says that proudly every time he appears. All right. Okay. Where are we on this case?
Your Honor, I have rent to retain of $2,016.44, court costs of $190, for a total of $2,206.44. Your Honor, I do believe this is the third hearing, so at this time we would request a judgment.
Right, but I get that you're questioning it. Where are you folks with everything?
Of course, the veterans have been slow responding. Drika Jacob at Washington's VA is working from home actually, and not as many hours. So she finally earlier this week got me information on how to apply online to a different fund through the VA, Emergency Assistant Trust Fund. And then I couldn't figure out how to apply for it online. So anyways, I eventually figured it out, but I'm still waiting for a response. So I have the copies of me applying for that. Madden Litton from the Senior Housing Bureau was waiting on me to let her know where I was with the VA. And around Wednesday, when I was still having issues getting a hold of getting responses back from Madrika, I finally responded to her, but I haven't had a response back. She said there was an opportunity that she could help us. So
that was who?
How Senior Housing Bureau of
Housing Bureau for Seniors.
Mm-hmm. Thank you.
Okay, and that's their fund where they could pay. She says you might have access to funding that could pay it all.
Right.
This agent Skip, or I can't remember what the funding's name is. Gotcha. Okay. Okay. So you've been working on it, trying to figure it out.
Right.
I'm shocked that the VA has not given you a response.
Well,
they did, but they didn't, and part of it is because they're not really open. And the beautiful whole process. We had this nice federal government that just won't work, and now everybody's trapped. And Ms. Matson, you and your client are gonna be mad at me, but I'm gonna tell you, we're gonna come back for a fourth hearing. I'm not kicking the vet out unless I have to. I'm just not.
I do want to say that I own the house. We own the house.
I know. I got
So I don't
you.
know
I
I
appreciate listen. I appreciate your entire circumstance. I'm just indicating that I'm not kicking a vet out because I know that there are programs there to take care of it, and that absent the ineptness sometimes of our federal government, this would be done. It would be paid for, and you guys could sleep at night, not worry about it. And I know since his difficulties, you've been struggling to try to make it all work. I'm not abandoning you at this point. It's just not happening.
Thank you.
That's just not the way I am. And plaintiff can be as mad as they want at me, and that's fine. I had people mad at me before. I got broad shoulders. I'm going to put it out 2 weeks so that the two things, so that hopefully the Veterans Administration can give an answer within that time. God only knows. But also the individual that you contacted at Housing Bureau for Seniors, if it's I think it's Skip, if it's that funding, tell them that you'd like to apply for that right away. I think what they're going to do is they're going to be waiting for the veteran to see what the Veterans Administration does before they do it, because some of that funding is limited. Ask them if you could get that so this can get paid.
Okay.
Now, how much is your monthly rent?
I think it's $8.96.
Okay. Are you in a position to pay anything toward your rent at this point?
Not at this point. He's only getting a certain amount, and we have, other bills of like $1,000 a month. And
That's what you guys are living off of right now.
right now, and I had a job at Myers. It didn't work out. They let go a lot of part-time people at that location. So now I'm currently been looking for another job, and I have a job opportunity with the Salvation Army and where we live, our local one. But they're waiting on a background check.
Got it. Okay, so here's what I'm going to do. November 14th, 2025. What time? 3 p.m. And it's likely if we don't have a resolution, I'm going to give them a judgment, but we'll figure something out. What I'd like to see is that between now and that date that you at least put $200, about a quarter of what's owed to the landlord.
Okay.
Okay, it's not much, but you don't have much to work with at this point.
Okay.
Okay.
We'll figure something out.
All right. I know you will, and I know.
Every day we're working on it.
I know.
Okay.
You guys take care.
I want to thank you, sir, so much.
We'll bring you a sandwich next time.
No, you don't have to bring me anything. Thank you.
Thank you.
Nancy, I think that's it.
That is all for me today. Have a great rest of your day.
You do the same. Court does call the case, Peninsula Place versus Andrika Underwood. He's right here. Hello, what's your name?
Andrika Underwood.
All right. And where are we with her case?
Total is 430407. 4304.07.
All right. And how are you intending on getting this paid, ma'am?
So I'm planning to just make payments. When the situation is, I went to Disney World last year on an internship, and I came back and things were really low, and I paid my moving costs and was trying to make a payment plan, but I was not making enough at all to be able to like.
Okay, so hold on. You went to Disney World, an internship? Was that part of
Disney college program.
Pardon?
The Disney college program.
Gotcha.
So, well,
So are you in school now?
yes, I go to EMU.
Okay, so you went and did that. You paid moving expenses to get yourself there to do everything.
Yes. And I was looking for jobs since last November. I didn't get hired. I started working. I got a job at the Standard in April, and yeah, so I just had to start then. And I just transferred from WCC. I have a half a little bill. I'm kind of in a situation right now, but I want to do
Okay, so hold on, take a breath for me, please. All right. What are you studying to be when you grow up?
musical theater.
What?
Musical theater.
Oh. What's wrong? All right, look, yes, lady. All right. Let's start this back up. How old are you?
29.
Okay, you're trying to get yourself through school. Trying to do everything so that you just have a better life, right?
Yeah.
And sometimes when you're doing those things, it all looks good and then it doesn't. Something happens, it doesn't quite work out, and then it's all looking different. And then you just think everything's all dark and you're not gonna make it, right? All right. So what year are you in school?
I'm in my third.
Pardon?
My third year, junior.
So you made it through two. You're in your third year. And you're just trying to figure out how you can get through that and then the next one, right?
I will say that I started college. This is my second time in college. And the first time I dealt with some apartment issues and
You dealt with what? I'm sorry.
I dealt with apartment issues.
Okay.
With I know sounds irrelevant, but I recently paid off that debt this past year. So like literally earlier this year. So that was
That whole adulting thing is hard, isn't it?
yeah.
Okay, listen. You're trying to do something with your life. And is the landlord open to some type of payment plan?
I don't have a note that says that, and
But she's trying to get herself through school.
she made a payment in early October. Got reversed for NSF. Then she did pay another 700 on the 17th.
Got it.
So
And I made a payment last night as well.
Okay, how much did you pay last night?
$198.
Okay, paid what you had, right?
oh, I've got that. So her balance is 4304 after that payment.
After that payment. Okay, let's.
I just started working on campus and I'm going to start work study as well.
Let me ask you this, young lady. Where are you originally from?
I'm a military kid.
You're a military kid.
My family is from Alabama and I grew up in Germany and I moved to Savannah, Georgia when I was 11.
Mom or dad in the military?
My dad,
Your dad? What branch?
Army.
And you're here trying to get through school.
Yeah, I had a VA scholarship at first and things didn't go well. But
But you didn't give up. All right, Mr. Fing. This is a veteran's kid. You know how I feel. She's also a young lady trying to get through school. You know how I feel about that. So everybody's going to do what we can. We're going to get her there. That's what's going to happen from my book. So we can
want
do it
to-
the easy way, or we can do it the hard way.
Well,
I'm just, I mean, I'm gonna be honest. And she went down to Disney World. I'm blaming it on that mouse. And that's why this is all messed up. It's the mouse.
you want to pass it and see what we can do today, or adjourn it till next week?
Why don't I
You want to
adjourn it till
cut her
next week
more
and-
slack on the redemption date while she figures it out,
Pardon?
or more on the redemption date? The disadvantage, of course, is coming back.
She's got her November rent.
It'll include November rent.
Somehow or another, we gotta get her, we're gonna have to include that anyway. So we gotta get her straight so that she can get through this semester. I want her in a position where come her finals, that's what she's focused on. And then we can get ourselves into that next semester. That's it. I'm gonna adjourn it out a week.
1 week.
Okay, 1 week.
Okay.
And so what you need to do, young lady, is you got the number to their office. I need you to call them, work with them. Let's see what we can work out to get this done.
Okay.
Give me your email. Your father's still in the military.
He's retired.
He's retired
Sergeant First Class, Field Artillery.
Excellent.
in,
I have a son.
is he in Germany still or he stateside?
You're still stateside. Yeah. We live in Howell.
You know, okay. November 7th, 2025 at 3 p.m. Okay, you'll need to come back then. All right, how are your grades?
We're doing good.
What's that mean?
Um,
My kids tell me that I have to be suspicious.
I have a research.
What?
I have a research presentation to work on, but I'm doing good.
Okay, what's that mean? Good.
I'm getting all A's.
Are you?
Yeah.
Or you just he just told you to say that to me. He just told you to say that, didn't he?
No.
Fine. You're getting all A's?
Yes.
Bless your heart. Are you really?
I am, maybe with a B. Maybe a B in there. I'm getting all A's, okay?
It just depends on how you look at it.
Yes.
Okay.
I'm getting all A's.
All right. Young lady, you're destined to be successful. So let's do our part and we'll try to help you through this little hump in the road, okay?
Okay, thank you.
You're welcome.
Your Honor, before we come back next week, or when we come back next week, I would like to remind you that Mrs. Fink has an active duty soldier right now.
Yes.
All right, thank
He
you.
does. All right. And so we'll get you through this, okay?
Okay.
All right. And when you talk to your dad, do me a favor. All right. He doesn't know me, but just tell him I want to thank you for his service. All right. And that I realize I get to do every day what I get to do because people did what he did. Okay.
Could
You're welcome.
we approach?
Yes.
All right, let's have a couple folks from BNR come on up. And while you're standing, I'll have you raise your right hands, and the Duplessis, if you'll raise your right hands, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
We do.
Okay, see you. All right, folks, I've reviewed what has been filed in this case, and frankly, it looks to me like it comes down to the issues raised in the letter sent on the 18th of June to the Duplessis by BNR Flooring, that a change in conditions of the substrate has negated the warranty on the floor. Is that essentially your position, BNR?
It was denied based on environmental and user rather than manufacturer installation. Was why the warranty was denied.
Right, that the substrate conditions will no longer meet the necessary flatness requirements for the floating floor.
As well as the rolling load, correct.
Okay, and that was the wheelchair.
Correct.
And how is that made clear to the customer what the restrictions are on a floating floor as regards to, and I think in this case, the assertion by BNR is that it's a wheelchair for a significantly oversized person has caused damage to the floor. Is that basically BNR's position?
Correct. The rolling load is making the floor fail.
Okay.
I can expand if you'd like.
Well, yeah, let's just assume for now that that's accurate. My question is, when somebody has a floor put in, are they notified of weight limits, stress limits? Are they told something so that they can consider whether this is the appropriate purchase?
Generally, during the process, our salespeople would do their best to learn how the floor is going to be used, what the conditions of the home, simple questions usually like, do you have pets? Do you have kids who use the floor? Those kinds of things. This being new construction also, and our salesperson with instruction from the builder on the type of floor that's, say, budgeted for or recommended or whatever conversations they may or may not have had. The salespeople would talk about that. Then as far as about how to use the floor and maintain the floor.
Okay, so actually, let me stop you there. So the Duplessis bought this as a new home?
Yes.
And the installation of the floor decision was made by the builder, not by the Duplessis?
The selection of these color, the exact product was made by the Duplessis. Their contract, of course, is with the builder, as is mine, ours.
Okay, so the choice of a floating floor, which appears to be the issue here. Am I correct about that?
That's primarily the issue at the end of the day, yes.
Okay, so did the Duplessis choose to have a floating floor? Or did the builder do it and they just picked a color?
There's many kinds of floors. They chose a product based on, say, Deanna has a good, or the salesperson has a good relationship, say, with the builder, likes the product. They like the color. I think there was a little hiccup with the discontinued product in the process, but that's neither here nor there. They ultimately chose a floor. Floating floor is generally a fantastic product, very durable for pets and kids and things like that. As Laura mentioned in her statement, and Deanna mentioned in her statement, she was never made aware that, a significant rolling load would be used. Otherwise, she would have offered a different kind of floor that would be more appropriate for that kind of use.
Okay. You were the saleswoman?
No, Deanna is our
Deanna. Okay. Okay, and the conversations, what role did the builder have in these discussions about the type of floor to put in?
I am unaware. Deanna's here. We could ask her to answer that question if you don't mind.
Okay. Yeah, why don't you have her come on up and she can have a seat over here.
We also have the builder here and the installer.
Okay. All right. And if you'd raise your right hand for me, please. Sure. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth. Go ahead and have a seat. Okay, floor choice. You were conversing with whom?
The builder. The builder said, hey, I'm sending clients in.
And your name is Deanna?
Correct.
Okay.
I budgeted for luxury vinyl plank, and I know what that means to him. And we have done homes with children in wheelchairs before, and we've talked about it, and we've done a completely different floor. We've done a glue down version of a luxury vinyl, but in this case, he wanted luxury vinyl, not a glue down. He wasn't aware that there was going to be a rolling load either.
And I'll go back, Sarah, I'll go back to you. If there's a glue down floor, does that increase the likelihood that the damage to the floor that had occurred in this case would not have occurred if it had been glue down?
It does increase that likelihood, yes.
All right, so you were discussing this with the builder, not with the Duplessis.
Correct. When they came in,
The builder came to you about the floor.
Yeah, they came to pick the color, and we went out and picked a floor, And unfortunately, I felt really bad that that floor had been discontinued when it was time to get ready to order it. It was discontinued, so they had to come back and pick out another floor. And they picked another color, and that's what we installed.
So in essence, you were a sub on this job by installing the floor, subcontractor for flooring. Okay. Okay, and from the Duplessis standpoint, do I have this right? This is the issue that we're talking about?
Correct, yes, sir.
Yes, sir.
Okay, so there seems to be, this is coming down to the awareness, in this case, I believe, of the builder as to whether there was going to be the greater than normal or anticipated load on the floor based on the size of the person using a wheelchair. So did this come up at all? Did anybody caution you? Tell me about that.
So from the day one, Your Honor, I originally designed this home because of our child being in a wheelchair. So if anything was to ever happen to us, he would have a place that was comfortable for him to live in. This was discussed with the designer, Adam Lanier. This was also discussed point blank from the very first day we met the builder, Andy Groom. This conversation has been this way since day one.
Can I say something?
Sure.
Sir, day one from when we met Mr. Andy Groom, the builder, I came with a photo in hand of my son, who was at the time living in a facility, with him in a picture in his wheelchair, with a story of why we were doing this and building our home this way. And he listened to our story.
Okay.
He saw a picture of him in his wheelchair.
So,
all right. Yeah. Yeah. So hold on here. So this is raising a separate issue. I was curious about all of this, and now I think I'm beginning to see the picture a little bit. The lawsuit here is, well, let me just confirm before I make that jump. The lawsuit is Duplessis against B&R Flooring. And it appears that B&R Flooring just installed the floor as requested by the builder. So I don't see that B&R Flooring has any role to play as a defendant in this case. Do you have any reason to believe that B&R Flooring didn't do what they were supposed to do?
So yes, sir. The first time Andy told us we were going to be talking to Deanna at B&R Flooring, we sat down with her, explained to her we needed certain criteria. One, it had to be waterproof. Two, it had to be able to sustain someone in a wheelchair. Three, something that would handle scratches. And four, we needed pets. Because at the time, we actually had a pet with us that we unfortunately had to put down 6 months after we moved into the house. These were our criteria from the day we first met Deanna. Point blank. This was never discussed to change from a floating floor to a glue down floor whatsoever.
That wasn't even brought to our attention.
Correct. Not one time did anyone at B&R Flooring said, yes, we need to change this flooring. These criteria have been met from day one. Like I said, Your Honor, when we started this process to build this home, was always the design for someone in a wheelchair. We sat down with her. Yes, she did this. The one flooring did discontinue. We went back in and picked out a whole separate flooring. Yes. Again, it was never discussed from Deanna's point on our end that this flooring.
Okay. Yeah, we're having some. Yeah, hold on. You're having connection issues here. Your voice is coming in and out, so I'm not sure if your location is problematic. So we're missing some of what's being said. Let me ask a question. Ms. Duplessis indicated that she showed, I believe it's Mr. Groom, the builder, the photo of your son. Did you show Deanna that same photo?
I do not believe so, sir.
Okay, so is there any way that B&R Flooring would know that there was going to be something, we have to be polite
Yeah,
here.
that was my
but-
highest priority when discussing flooring.
Right, but my question is this, did B&R Flooring have reason to believe that there was going to be greater than normally anticipated weight from a wheelchair on the floor? And how did they have that? How did B&R Flooring have that anticipation?
We told it to him personally, but part of the evidence that we.
Okay, Mr. Duplessis, how about you let Ms. Duplessis speak because her voice is coming through, yours isn't.
Yes, sir.
Okay, Ms. Duplessis,
Yes.
how did B&R Flooring know that your son was significantly larger than normal people using wheelchairs, and that there would be a significantly greater weight stress on the floor? How was B&R Flooring notified of that?
I was constantly telling them that was the main reason about our choice of our floor,
Okay, what were you telling them?
that it needed to be waterproof. It needed to take his weight and his size of his chair, the wheels of his chair, everything that
Okay.
he needed.
All right, so I want to be clear here. We're not talking about conversations with Mr. Groom, conversations
Correct,
with B&R.
Deanna. With
Okay.
Deanna.
And did you tell them the weight of your son?
I did not specifically say his weight, no, because he's my child and I don't talk about him in that way.
Right, no, I understand, but I'm just trying to figure out how much B&R Flooring knew. So
Well, I can tell you this. And part of the stuff that we gave you as proof, I had a conversation with the person that was going to be coming in and making the niche for our son, who they met when they came to measure him for his bathroom, ADA bathroom, which that person is there. He came in and had to take the measurements of everything to put the bench in for our son that is in the wheelchair.
Right, and is that somebody who's a B&R employee or
Yes,
somebody
sir.
who is part of the building crew?
I don't remember his name, but he's sitting there in that courtroom. And part of the conversation was, I got the call from Deanna about meeting the floor guy to meet there with him to get the niche and bench right for our son's height measurements between, and it says the time.
And was your son present at any of
Yes,
the
sir.
conversations?
Which we also gave you the picture of him that day. They're
Well,
waiting
I
for
see a
them.
picture, so he was present there. That the photo
Yes,
is
sir.
him being present at a meeting with whom?
The people,
With
the
whom?
installers.
Okay. All right. And I think we have the installers here, is that right?
We do.
Okay, so first of all, before I call them up, Deanna, Ms. Duplessis said she actually discussed with you the concerns of a special floor, or the special concerns about the ability of her son, who
Actually, I constantly had anxiety talking with her about all the things that I needed for my son because I'm afraid of picking the right one or the wrong one.
right, okay, so you want to fill me in on that?
Yeah, if we would have had that conversation, we would have.
We did.
Down.
Okay, so,
In the end, I've done many homes with people in wheelchairs, and we put glue down floors, period.
did you, at any time that you were meeting with Ms. Duplessis, did you ever see a photo of her son, or was her son ever present at
Never.
any of your meetings?
Never.
No, he was not.
Okay. And Deanna's just told me she never saw a photo of your son in a
No.
wheelchair. Okay. And you said you didn't feel comfortable disclosing the weight of your son. How did you make Deanna aware that there was going to be an abnormal stress on the floor from your son being present in the home in his wheelchair?
I don't find that I didn't disclose it to her. I didn't talk about it because I don't talk about my son in that way. I didn't say, oh yeah, my son weighs 300 pounds. This is why I need this kind of floor. I don't talk about him that way.
Can I interject, Your Honor?
Yeah, hold on. As I pointed out at the beginning, it's not, you're asking me to decide this legally. So the questions I'm asking go to the law. I need to figure out exactly what was said, what people knew, in order for me to figure out, one, who may be liable or where the decision was made. So,
Yes, sir.
Ms. Duplessis, to summarize, what you've just told me is your conversations with B&R Flooring, your son wasn't present, so they didn't have they didn't have their own ability to see him and understand what the weight stress would be on the floor. You didn't tell them your son's weight. Is there anything that you told B&R that would indicate to them there may be more than the normal weight stress on a floor for the floor they were installing? Did you ever say anything to them along those lines?
What does my son's weight have to do with?
Okay, no, you're not asking me questions. You need to answer my question. Yeah, I'll answer your question. The whole point of B&R is that there was an extraordinary weight stress on the floor given the size of your son. And we'll deal with that in a minute, but I need to know, was B&R Flooring aware of the size of your son at the time you selected their flooring?
I already answered that and I said no.
Okay, all right. But you did tell me that Mr. Groom, as the builder, was aware of the size of your son. Is that right?
Yes, sir.
And that's because your son was present, or you said you showed him a photo of your son?
In the very beginning, I showed him a picture of my son. And
Okay.
he met, yeah,
And he met your son? Is that what you're saying?
they met my son,
They being whom?
the people that installed the flooring.
Okay.
It says in that
Let's have
text.
Okay. Dan, if you'll step back, and whoever installed the floor, come on. And raise your right hand, please. Swear the testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes.
Right,
My name is
see?
Eric Hedges, by the way.
Eric?
Eric, yes.
Okay. And Eric, you work for?
I own my own company. I do subcontract for B&R.
Okay. Okay, Ms. Duplessis, and so you're the one who installed the floor in the home?
Yes.
Okay. And did you have any role in the selection of the flooring?
No.
And Ms. Duplessis indicates that you met her son?
No, I never met her son until the project was completed.
Did you ever see a photo of her son?
That is not true.
Okay,
As you can see, the
Ms.
floors-
Duplessis, I give everybody a chance. I'll come back to you. Okay, and now remember, what I said ahead of time was that I'm very likely to hear different stories from folks on these cases. And remember, I wasn't there. So
I
I've told
understand.
everybody, okay, Ms. Duplessis, I'm just reminding you of what we talked about prior to mediation, which is in these cases, we hear very different versions. And I'm hearing a very different version. So sit tight. I'll give you a chance again.
Yes, sir.
Okay. All right, Eric, go ahead.
I had not met him until the project was completed, till I came back to start doing repairs.
And that was how long after the installation?
Oh, wild. She's got a timeline.
Okay, but I mean, it wasn't a week later.
No, it was
years later.
Yes, it was down. Even a year to months.
Okay, so at the time you installed the floor, did you have any reason to believe that the choice of the flooring that was being put in the home was inappropriate, given what you suspected the ongoing demands of the floor would
No,
be?
I had no idea. It was perfectly fine floor for family.
Okay. All right. And did you understand there was going to be a wheelchair?
No, I had no idea.
You had no idea even about the wheelchair? Okay. Okay. All right, thank you. And is Mr. Groom here? If you come on up. Raise your right hand for me, please.
Yes.
Swear the testimony in this case be the truth, whole truth, and nothing but the truth. And do I have your last name right? Groon?
It's Gruen, G-R.
Oh, Gruen, U-E-N?
H-N.
Okay,
Yeah.
go ahead, have a seat. And Mr. Gruen, you're the builder in this case?
I am.
Okay. Were you involved in discussions with the Duplessis and with BNR about a selection of a floor?
Yeah, we had a budget for LVP flooring. Adam Lanier designed their plans. And anyways,
Who is the designer?
Adam Lanier, he was a plan designer.
And who does he work for? Is he his own shop?
Yeah. Yeah.
And so he gave you a design on a floor.
Yeah, he just gave me the house plans.
Okay, the house plan.
Yeah, yeah.
And how did the floor selection come about?
I sent them to B&R to pick out a subfloor or an LVP flooring, engineered hardwood. B&R supplies all the floor covering, so tile backsplashes, carpet, engineered hardwood.
Right.
And so kind of during this last time frame, we put in lots of LVP flooring. I've worked with Deanna for almost 25 years. We put in a lot of floors. We've done a lot of work together over the years. And so as far as their son's concerned, I didn't actually meet their son until after they moved into their house. They moved in beginning of June. I came over sometime middle to end of June, and I was shocked. I couldn't believe my eyes.
And what do you mean by that?
He was in a wheelchair, and they told the first time we met, they told me they had a special needs child, and that was all they told me. I feel like it's not my place to ask and pry and for information, right? Like they're going to tell me, they have a special needs child. That can mean a lot of things. So, anyways, when it came to flooring, those were the options. Luxury vinyl plank, it's floating floor. There was nothing on our radar. It was just, go pick out coloring selections, your tile backsplashes, things of that nature. And away we went.
Okay, so after the Duplessis moved in, you came out a couple weeks later.
Yes.
And you said you saw their son and you were shocked by his size because you had no anticipation that.
No, I'd never seen him. I just knew he was a special needs child.
Right. But you said you were shocked. And
yes, I was shocked that he was in a wheelchair, and I just was like, oh, I kind of one of those like, oh, I didn't, that was not on my radar.
Okay. If you were aware of that size, of the size of their son at the time that you were talking about the installation of the floor, would that have changed your view as to what the appropriate product would have been?
Yes, I would call Deanna. I would ask her. That was a red flag for sure. I was like, oh, that would have changed what would have been put down. Absolutely.
All right, Ms. Duplessis, go ahead. Anything you want to say?
What was that? Sorry, I'm sorry, I couldn't hear you.
Yeah, I said, go ahead. Is there any, you've heard Mr. Gruen, you've heard Eric, you've heard Deanna, all say that none of them at the time of the selection of the floor or the installation of the floor, were they aware of the size of your son, which they all agree would have changed the product that would have been selected for installation. So what's your view on that?
Sir, I'm actually speechless.
Okay, so you think they're not being truthful with me?
That's an understatement.
Okay, and you believe that you were right up front with the demands that were going to be placed on the floor by the size of your son, and that they knew about it at the time they assisted you in selecting a product. Is that your position?
Yes.
Yes, sir.
Mr. Moon, thank you. And who from BNR has been out subsequent, and once you got the complaint about the floor?
And
Only the
sir,
installer.
So Eric, if you'll come on back up. And I'll remind you, you're still growth.
Yes, sir.
Okay, so you went back out when the Duplessis called and said there were issues with the floor.
I've been out a couple times to fix different random repairs.
Okay, and so what did you, as the installer, see as the cause of the damage to the floors?
So the first time I went out there was to fix a couple. So the floor can gap in two different ways. It can gap in the head seam where the narrow edge of the board goes together, and it can gap in a length seam where the long edge of the board goes together. The first time I went out there, it was head seam gaps, which you can knock back and glue back into place. One of the times I went back out there, Mr. Gruen had the framer meet me out there, and the bottom of the tongue and groove subfloor had broken in the hallway, and the floor had actually, the subfloor was moving, which caused the floor to crack, which required me to glue in 2 more boards down the center of the hallway. Then I came out an additional time to fix gapped boards, which is through the kitchen where it gapped in the length seam. And once it does that, that's completely failed. And what had happened was because of the rolling load, you have the groove of the floor and the tongue locks into it. Because the rolling load causes the flex, the bottom of the groove had broken, so the tongue won't lock in any longer. And that's how it failed on the length seam. Which is basically a complete failure.
Okay.
Sir.
Was there any other, I'll get back to you, don't worry.
Okay, sorry.
Was there any other cause that you saw to the issues that the Duplessis were having with the floor?
The framer was complaining. I guess it's not abnormal, but it's not standard. Usually the joists are spaced 16 inches apart. And in this house, according to the plans, they were spaced, it's like 19 and like 7/16. I forget what the spacing was.
So 3.5 inches.
Yeah,
wider than
it's still
typical.
divisible by 8. So the boards still end where they should, but to save money, you space those joists out a little bit. Is my understanding. I don't, this is what I've been told by other contractors. That's why you space them out.
But as far as the floor having issues, is there anything other than the weight of the chair that was in your mind contributing to the floor having issues?
No.
So in your mind, it was clear that it was the weight of the chair?
Yes.
Okay. Mr. Plessis.
Yes, sir. I just would like to add that my son hangs out mainly in his room, and in his room is not the area that all these problems are happening.
Okay.
It's
Does
in
he
the
ever go in? Does he ever go into the kitchen?
Well, yes, he goes in and out of there, but it's one spot in particular that this is happening in. It's not even an area that he stays in.
Okay.
I had one thing.
Yeah, and I'll come back to you. All right. Eric, go ahead.
Just because the floor hasn't moved and separated in places doesn't mean that locking mechanism hasn't failed, and it's still together, just hasn't moved apart yet because of the weight of the whole floor.
Right.
So there could be damages in other spots that haven't moved apart yet as well.
In installing the floor, is there anything defective about the product in your mind?
No.
Okay. And have you installed the glue floor as opposed to?
Yes.
And would that have made a difference in this case?
Yes.
And is that typically a more expensive version of the floor?
I don't know the price, but the cost of installation is doubled.
Okay, thank you. And Deanna, one more time. Seat, I'll remind you, you're still under oath. Did you have any reason when the Duplessis came to you to select a floor to suggest to them that they should consider the glue version of the floor?
If I would have known about a wheelchair, absolutely, I would have done that. I did not know.
Thank you. Mr. Duplessis, you get the last word.
Yes, sir.
Yes, sir.
I said you get the last word. Anything else? You've heard everybody's testimony. Anything else you want to say?
Like I said, honestly, I'm just flabbergasted by the.
We sent you, Your Honor, we sent you proof that Deanna knew our son was in a wheelchair. We sent you proof that we took a picture the day we were supposed to meet the installers out here. She flat out knew he was in a wheelchair. Our builder knew he was in a wheelchair. They knew that. They came out here to take measurements for his bench and his niche for his ADA bathroom, his shower. They knew he was in a wheelchair. They're lying through their damn teeth. Point blank line, all of them.
Okay, so I didn't see anything in the exhibit you submitted that indicate they were aware of the size of your son. So was what indicates
They knew he was in a wheelchair. They did not suggest putting a glue down floor in. If that's the standard for being in a wheelchair, the weight has nothing to do with this. Nothing. He's in a wheelchair. They knew he was in a wheelchair from day one. They should have offered a glue down floor and they did not. None of them did.
Okay, thank you. Okay, let's deal with that issue. Eric, come on back up one more time, please. I've heard some testimony about this floor is okay for folks in wheelchairs, but it's the size of the person in the wheelchair in this case, which is the difference. You've installed lots of floors. You tell me your version of that.
I would not suggest this floor with someone in a wheelchair.
Okay, straight up, you wouldn't.
No, something needs to be fastened to the ground.
Okay.
Can I say something, Your Honor?
In just a moment.
Thank you.
Okay, now, they did submit a photo of their son in the house where there's no flooring there, just a subfloor. Has BNR looked at that, or have you seen that?
No, I haven't seen it.
Okay, you've
I've
looked
seen
at
the
that.
picture, yes.
Okay. And well, do you have the picture? Can you call it up?
I did not print the picture. I apologize.
Okay.
Looks like the home was under construction
Right.
when the picture was
Eric,
taken.
step on up your way from it. So this is the photo here.
Yes.
Were you present at this time? Did you ever see, I think you told me you never saw the son prior to.
No, So usually the first thing we do when I show up on a job is we start cleaning the floor to get all this, see all the mess here.
Right.
I wouldn't even want to stock the job with that because if I was to set a pile of boxes on that debris, I would damage the floor. So the first thing I would do is come in, sand, and start sweeping and clean the house. So it doesn't look like I've been there.
Okay, so at this point, you haven't been there. You never saw their son in the home prior to the installation of.
No, the homeowner, I had an issue with the homeowner and they weren't allowed in the house after the first week we were there.
Okay. Okay, thank you. So who was present when you took the photo of your son on the subfloor in the house?
The two installers, myself,
Okay, well,
my
Eric
wife.
just said he wasn't present.
Yes, sir, he was there. If you go back, I don't know if you can pull up the information on the date and time that picture was taken, which was April 19th at 10:31 in the morning. The previous evidence I sent with the text message was dated April 18th, where we discussed with Andy Green that we would be out there on the next day, the 19th, for them to get measurements of him in his chair. They may not have been present in the house at that split second when I took that picture, Your Honor, but they were there. They showed up, they took the measurements in his bathroom, in his shower to make sure the bench and that was at the right height for him to get in and out of his wheelchair. That picture was taken the day we required that we decided to make that meeting per Deanna to have her installers there.
That was us waiting.
Okay, so what I see in the text is that there was a meeting set up to discuss the bathroom niche and bench, but it doesn't say anything more than that. Just says there was going to be a meeting on the 18th of April. And then it goes into paint selections.
Correct, Your Honor. Like I said, the text clearly between my wife and Andy Green clearly states that Deanna set this time up to meet her installers. So the bottom line is, she knew our son was in a wheelchair. She knew flat out he was in a wheelchair because she set up the timeline. The discussion with Andy and Mr. Green can sit there with a smug and smile on his face laughing about this. He knew it too. They both
Okay.
knew my son
Hey,
was in a wheelchair.
Mr. Duplessis, let's take the personal out of this. I'm asked to decide the legal issue. And it
Yes,
doesn't
sir.
help have the personal disputes. I'm not resolving those. Okay, so what I see is a text or an email. I'm not sure what the version is here because I can't tell
Text.
from what. I think so. So it's a text record just saying that your son would be there on some date. I don't see any other confirmation about anybody meeting your son. It just says, yeah, he'll be there. Or we hope that the flooring guy will meet with them,
Say so to them.
get the height and measurements. And then you have the picture, but nobody else in the photo. And Eric has said that didn't happen while he was there. And Mr. Gruen said that when first time he saw your son was 2 weeks after you moved in. So I have the email or the text saying that your son will be there, but I don't have more than that.
Yeah. Yeah.
Okay, anything else, Ms. Duplessis?
No.
No.
And did you want to say something?
Yes, I just wanted to state that at the time of the text, as well as the picture, that was well after the flooring selection had already been made. As well as it's not really the weight in the rolling load, just the fact that there is a rolling load on the floating floor.
Okay, well, but that means that any size person in a wheelchair is going to be
Correct.
a rolling load. And are you saying the BNR had no knowledge that somebody in a wheelchair was
Correct.
going to be in the home?
Correct.
And if there had been
Wow.
somebody been told that there was somebody in a wheelchair, you would have suggested the glue down?
Correct.
Okay.
Whatever the case like that. They lie.
It's frozen. Just wait till I ask a question, please. And what was the installation date on the floor?
The floor was installed starting on,
That's when we finished.
oh,
Well, when did,
Yeah.
yeah, when did, well,
about April of 2022.
do you have dates in
April 18th.
April 18th, 2022 was when we began the installation, and all work was completed by the end of June.
So by the end of June, nobody from BNR had either was aware that they had a son in a wheelchair. Mr. Gruen has testified that he was aware that there was a special needs child, but not that the child was in a wheelchair. Is that
correct?
BNR's position? Correct. And Eric, is the installer, prior to completing your job, at any point did you become aware that the special needs child was a child in a wheelchair?
No. The homeowners were not allowed on the job after the first week I was there.
Okay.
So what?
And during the first week that you were there, was he out there
No.
and so did you have any idea that you were constructing a floor for somebody, for a resident of the home being in a wheelchair?
No, I did not.
And Mr. Gruen, if you'll replace Eric, let me ask another question as we're sort of getting this. Were you aware, you said you were aware of special needs, you were shocked when you saw their son. Is it shocked that he was in a wheelchair or shocked that he was of the size, or both?
The wheelchair.
Okay, and you had no idea you were building a home for a family that was going to have a wheelchair?
I did not.
And you weren't aware of it until you walked in the house after they had moved it?
Yeah, and like I said, I was shocked. I mean, just.
That's gonna burn you.
Yeah. Okay. All right. Thank you. Anything else, Mr. Plessis?
No, sir.
Okay.
Well, actually, I do. Actually, you should have brought up the whole text message again. That's proof that he was in a wheelchair.
Text message is submitted, and there's nothing in there about your son being in a wheelchair. It just says that you are hoping to introduce your son to them, and it doesn't say anything beyond that I have. All right.
Niche and bench right for our son's height measurements.
Right.
Why would we even bring that conversation up if it would not have something
All
to
right,
do with
Mr.
him being in
Duplessis.
his wheelchair?
Okay, thank you. There could be a lot of reasons why you would bring it up. That doesn't tell me that the person's in a wheelchair. So.
Okay, believe
that
the
could-
lies. Believe the lies.
That could be one possibility, but we have to have a little bit more certainty that these folks knew. And so I have the testimony of the builder, the installer, and the
And like he stated earlier,
Hey,
they've been in
no, we're
business
not
for
arguing,
25
Mr.
years. Do
Duplessis.
you think he would not lie for them? Do you think they would not lie for them? Really?
I'm going to ask,
They've been
I'm going to
working
ask you
together
to
for
be muted.
25 years.
You're not doing your case any favors. All right, I've reviewed all the exhibits that have been submitted, both before the trial and during the trial. I've heard the testimony of all the parties in this case. And what we have here is the damage to a floor that the Duplessis have filed a claim on about 2 to 3 years after apparently moving in. And I've had testimony from the installer who said the damage appears to be related to the presence of a wheelchair in the home. And the builder, the installer, and the seller of the floor all indicate they had no knowledge of a wheelchair being in the home prior to the floor being installed in the home. The Duplessis disagree with that. They said they told these folks, but I have the statements of 3 different people who all have very similar versions of it, which is they had no idea. And Mr. Gruen indicates first he knew of it when he came to the house a couple weeks after the Duplessis had moved in. So the response to having somebody in a wheelchair residing in a home, I've been told, would be to recommend a glue-down version of the floor, which from an installation standpoint, apparently would be about twice as expensive as the normal provision of the floor or installation of the floor. But nonetheless, there was nobody who was tipped off that this should be a glue-down version as opposed to a straight installation of the floating floor prior to the installation. Because the Duplessis have not proved to me that there was a violation of the obligation of B&R Flooring or any of the other potential parties, none of whom were named. The only action in this case was against B&R Flooring. And there's no indication to me that they were aware that there was a wheelchair that would be permanently resident in the home. Because of that, I will dismiss the claim. Thank you.
Fucking bullshit. Fucking worthless fucks.